Everyone, this is, you're all aware, this is the Benton County Planning Commission meeting of April 29th. And I will begin with a roll call. So commissioners, as I call your name, please respond with a here, an I, or even a yo, something. Commissioner Bisco. Commissioner Cash. Participating remotely, so it may take her a second. I'll proceed and come around to Commissioner Cash in a moment. Commissioner Fulford.
Here.
Commissioner Lee.
Here.
Commissioner Struthers.
Here.
Commissioner Wilson.
Here.
Vice Chairman Heyman.
Present.
And circle back again and ask if Sarah Cash, Commissioner Cash, is available. Yes.
No, yes, I'm here.
Very well. Good evening. I'll note for the record that all 8 appointed commissioners are in attendance and represents a valid quorum. There is a slight change to our agenda in that we do not have our minutes prepared and distributed to be approved. And so we are going to jump right into the main event for the evening, which is why I imagine you are all here. And this is a larger audience than we generally have for our Planning Commission meetings. And so I think it's fair to assume that this will be the first time you have observed a Planning Commission meeting. And so I will try to provide some annotation as to what's going on during the agenda, just so that you can follow along more productively. We are scheduled for 3 hours and wrap up at 9 o'clock. But I know I get tired before then and my concentration begins to waver. And so if I look at my colleagues and their eyes are glazing over, we may very well adjourn prior to the full 3 hours. We are scheduled again for Thursday evening. And so we do have ample time to cover all of the input. We want the input. And so we have Thursday evening. And in fact, we have next Tuesday as well, should we not get through all of the public comment. To begin the hearing, I have quite a bit of information that I need to read into the record. And I apologize, I will have to read it because I can't do it from memory, but it's all important information. It's not like your user agreement on an application. This is actually important information and will provide some insight of how the hearing is going to go. This is the time and place for the public hearing in the matter of LU-24-027. The subject of this public hearing is an application for a conditional use permit to expand an existing landfill. The application is Republic Services and the property owner is Valley Landfills. Oregon law requires that I make several preliminary announcements for this hearing. This is a quasi-judicial hearing and it will be conducted pursuant to Benton County Development Code sections 51.705 through 51.725. In a quasi-judicial proceeding such as this, it is the Commission's duty to apply the law, not revise it. The Commission must determine whether the applicant has met all of the applicable criteria in the Benton County Development Code. The Commission will consider the record as presented and will also consider any new testimony or evidence that is submitted into the record. Please do not communicate verbally or in writing with the commissioners outside of this hearing process. And that's important. As we go on break, we're not being impolite. We just don't want to have a conversation about the content of this hearing one-on-one. The theory is we all need to have access to all of the information collectively. So we're not avoiding you. It's just we would prefer not to have a conversation outside of this hearing. A staff report has been prepared for the application, and the staff report has been available for 7 days before tonight's hearing. The staff report identifies the approval criteria that apply to the applicant's proposed development and analyzes those criteria. Testimony and evidence should be directed towards the applicable approval criteria. If you believe other criteria apply in addition to those addressed in the staff report, identify and discuss those criteria and explain how and why you believe they apply to this application under consideration. A person may submit any written material while the public record is open on the application. Any written materials received by the county staff during the time period in which the record is open will be placed in the record. Written materials submitted during the public hearing must be presented to the county staff in order to become part of the record. We have our public information office available to accept that information towards the back of the room. No screen presentations are allowed. If a person intends oversized poster boards, reports, or pictures used in their oral testimony to be placed in the record, copies must be submitted to the county staff while the record is open. If they are not given to staff, they cannot be included in the record. Following is a question to the planning commissioners. Does any member of the commission wish to declare an ex parte contact, conflict of interest, or bias in this matter? I see and hear none. And Commissioner Cash, could I get a confirmation, please? Was that Commissioner Cash? I couldn't hear.
Sorry, I have to unmute each time. No, I do not need to declare ex parte.
Very well, thank you. This question is to the audience at large, including the applicant. Does anyone participating in these hearings wish to challenge a specific commissioner on ex parte communications, conflicts of interest, or bias? And again, I'll wait a moment to see if there's anything from our remote audience that we'll need to address. See none? We are aware of none. I will now go through the hearing procedure for tonight. The procedure is as follows. The staff report will be presented by the county professional staff. The applicant will then present the case in support of the application. We'll move then to testimony from other persons in support of the application, limited to 3 minutes. Then testimony from persons opposed to the application, again limited to 3 minutes per person. Testimony from other governmental bodies. And finally, the applicant may present rebuttal, which is limited to addressing any issues raised during testimony since the applicant's first presentation. The commissioners may ask questions of the staff or any persons providing testimony. However, the purpose of public testimony is to provide information for the commissioners to consider. The public is not permitted to ask questions of the staff, the applicant, or the commissioners. Any person wishing to present additional evidence and testimony to keep the record open to respond to new evidence must make that request before the public testimony portion of this hearing is closed. Following applicant's rebuttal, I will ask whether any person who testified requests an opportunity to present additional evidence or testimony. Upon such request, the commission will either continue the public hearing for a period of no less than 7 days, or will leave the record open for no less than 7 days for an additional written evidence. If there's no request to submit additional testimony or evidence, the public hearing will be closed, the record will be closed, and the commission will proceed to deliberations and make a decision. Now, all of that will not happen tonight. We won't get through all of it. We'll go through this procedure again if we have another session on Thursday night, so you hadn't needed to memorize that procedure. If you are a participant in this hearing, the commission expects you to abide by the following rules. Please be respectful of all participants. Speak only in the order of proceedings or when recognized by the chair. In testifying, please do not repeat previous testimony made at this hearing. Just note that you are in agreement with such prior testimony. Be advised the chair may halt testimony if it has become irrelevant, abusive, or clearly intended to harass or intimidate the participants in this hearing. Any written exhibits you want included in the record need to be handed to our public information officer's staff at the back of the room for marking before presenting to the commission for consideration. Any multimedia presentations is considered written testimony and should be submitted in the same manner as written testimony. No screen presentations are allowed during oral testimony. All testimony and evidence must be directed toward the applicable criteria in the Benton County Development Code or other criteria which the person believes applies to this decision. Failure to raise an issue in this hearing accompanied by statements or evidence sufficient to afford the commission an opportunity to respond precludes appeal to LUBA, the Land Use Board of Appeals, on that issue. The failure to raise constitutional or other issues relating to the proposed conditions of approval with sufficient specificity to allow the commission to respond precludes any action for damages in circuit court. To have standing to appeal the decision of the Planning Commission, you must present oral or written testimony to the Planning Commission prior to the closing of the record. Except for the applicant, verbal testimony is limited to 3 minutes total per person. Please respect the time limit so others have the opportunity to testify. The public hearing is now open and will begin as previously discussed, the presentation of the staff report. Ms. Sheets.
Thank you very much. I am at the end of a 3.5-week cold. So I will try to pronounce my words clearly. Again, my name is Petra Sheets. I'm the planning director here at Benton County, and we are gathered this evening to consider the conditional use to expand the Coffin Butte landfill. Republic Services is proposing to expand the existing landfill operations south of Coffin Butte Road, construct an 1,800 square foot employee building with off-street parking, modify an access road, and relocate leachate activities, portions of a perimeter landfill road, an outbound scale, and construct a shop and maintenance area. The applicant is also proposing to modify access roads north of Coffin Butte Road. We'll start with some background. In concert with the recommendations from the Benton County Talks Trash process that occurred a couple years ago, the county joined third-party land use and engineering professionals. And so I'm going to take this opportunity to introduce ourselves. I did myself, representing the Community Development Department. Sitting here at the table, I'll have Public Works introduce themselves, and then we'll have our third-party consultants do the same.
Thank you, Petra. I'm Jesse Winterroad with Winterbrook Planning, and we are a land use consulting firm.
And I am Larissa Gladding. I'm also with Winterbrook Planning.
I am Ellery Howard with Mull Foster Alonji, and I will let the rest of the MFA team introduce themselves as well.
I'm Eric Coffin with Mull Foster Alonji.
Chad Darby with Mull Foster Alonji. I'm a principal air quality consultant supporting the odor review.
I'm Jim.
Go ahead, Jim.
I'm Jim Gokora with Mull Foster Alonji.
I'm Bill Beatty with Mull Foster Alonji.
And I'm Brian Snapper-Zugis with Mull Foster Alonji.
Is that all of you?
That's all of us. from
Okay.
MFA.
And we also have a transportation engineer consultant, Sean Keller with Keller Engineering. I'm not sure if he's online. If he's not, I'll make sure that we get him entered into the meeting. So just to give you a sense of where we're at, this has been a long process since we got started. There was a pre-application conference in June 27th of 2024. And then there was a long pre-application process that went through the summer, fall, and into the winter. And where we're at now is that in January 15th of 2025, we did have a complete application and moved into the review process. So this evening represents the first hearing of this application. So here we have a timetable for reference. Slide. Move into the proposal description. So here's another representation from the application, or the staff developed this alternate map of the application, and our consultants here will help point out spatially the project description. So there are tax lot 0801 is approximately 89 acres. It's already in use for the and this is the existing land use area. The area of the proposed improvement contains access roads, a scale house, and scales. These tax lots also contain emergent wetlands, and these wetlands are vegetated non-channel systems that are not influenced significantly by tidal waters. They are usually relatively small and have over 30% vegetation cover, including trees, shrubs, grasses, and the like. And that's on the eastern portion of that tax lot. Tax lot 1101 is approximately 4 acres. The majority of this property is grass, while the eastern edge is treed. And this tax lot is currently developed with VLI offices, that's Valley Landfill's offices. And this tax lot also contains the emergent wetlands on the western and northwestern edge. Tax lot 1107 is approximately 59 acres. That's currently developed with an access drive, leachate, pre-treatment and treatment buildings, parking and maneuvering areas, leachate ponds, and a pre-treat pond, excuse me. Aside from the leachate ponds, the improvements on this tax site are obsolete infrastructure that has not been used since the early 2000s. The existing improvements on tax lot 1107 are situated on the northern portion of the development site, which is relatively level. From the current developed area, the site slopes upward to the south with an elevation change of 60 to 160 feet to different points along Tampico Ridge. The undeveloped portions of the site are vegetated with grasses and trees. This tax lot contains a likely abandoned but mapped great blue heron rookery in the northwest quadrant, along with a small area of emergent wetland in the northeast corner. Tax lot 1108, approximately 29 acres, already in use for the existing landfill, is already in use for the existing landfill area. The area the proposed improvement contains access roads, a scale house, and scales. These tax lots also contain the emergent wetland on the eastern portion. Tax lot 1200 is approximately 82 acres, and the northeastern portion of the site contains native vegetation and trees. There is also a buffer of trees along the eastern property line abutting Highway 99. The center portion of the site is currently developed with a gas-to-energy plant, gas blowers and flares, parking areas, and drive aisles. The approximately 20-acre center area that surrounds the gas-to-energy plant is leased by VLI to Agri-Industries, Inc., and has historically been farmed for grass. the land south of the fields is steep sloping topography that is vegetated with Douglas fir surrounded by native trees. This tax slide also contains a mapped but likely abandoned great blue heron rookery in the north central area quadrant, along with the emergent wetland and forested wetlands. The applicant adds on in exhibit BOP on page 11 that row crops are also farmed on the 20 acres of that tax lot. Slide, please. This is another representation of the site. We'll move on to a representation of the public agency comments. Slide. What I chose to do here was that we chose to, we have, there were a lot of public comments. Between April 22nd and this evening, approximately 185 to 190 have been received. And so while we've received them, it's been my intention to scan them, file them, and post them in batches. And so we've been trying to do that iteratively. But as we've been doing that, we've been using different methods to thematically represent what they look like so that Planning Commission has a general sense in those thousands of pages, kind of the weight of the different concerns and comments that folks have. All of the comments are against the landfill, but for two are in favor. And I'll just point out that some of the primary or most comments that we're seeing are the leachate, and leachate is that liquid when the water percolates through the waste. Also traffic, odor, water quality, the origin of the waste, PFAS, which is a synthetic chemicals that's used from industry that ends up in landfills, and that's been around since the 1940s. So those are some of the predominant themes and of the comments that we've received. So we are updating this graphic as we continue to receive additional comments. Slide. As part of the land use process, we're responsible for asking agency referral comments from agency partners from around the region that may be impacted or have some authority or vital interest in the site. And here's a list of the agencies that we solicited comments from. The highlighted areas, the highlighted lines are the agencies or groups that we received comments from. The Benton County Environmental Natural Resources Advisory Committee is a committee here that here at the county that did provide comments. Their comments did come in a little bit later than the other agency comments. So in the staff report, we had not taken staff time to reflect upon those comments. However, they are in the record. They are in the materials that the Planning Commission has before them. And in the subsequent draft of the staff report, we will make comments on their comments. Oregon Department of Fish and Wildlife provided information around the rookery of the heron, and the Oregon Department of Geology and Mineral Industries did not have any substantive comments for us. Today, however, we did receive comments from ODOT. And so, again, in this substantive report, they will be considered and incorporated into the report. Naturally, we did not have time to review those comments. They will be posted to the record and on the web tomorrow. Slide. Next section is we're going to start discussing the relevant code chapters. Slide. And there's 5 relevant areas of the Benton County Development Code, but we're going to be focusing on 3 this evening. There's the Development Code Administration, General Review Criteria and Procedures, the Forest Conservation Zone, Landfill Site Zone, and the General Development Standards. Slide. And here are some of our key findings. BCC 77 landfill site zone, conditional uses approved by the Planning Commission, states that conditional uses are approved by the Planning Commission. So tax lot 1107 proposes to expand the existing landfill operations, including the working face and waste disposal area. Tax lot 1108 proposes to access road with those modifications. And I'm sure that the applicant will go into more detail on this. Slide, please. BCC 53, General Review Criteria and Procedures, is rather general. It states that the decision to approve a conditional use permit shall be based on findings that proposed use does not seriously interfere with uses on adjacent property, with the character of the area, or with the with the purpose of the zone. Staff determined that in the case of the landfill, that noise, odor, visual, traffic, and groundwater impacts are the most relevant influencers. And this subsection 1 is relatively general, and so I'm going to spend a few moments more specifically defining this criterion. Slide. The first term that I'm going to define more specifically is seriously interfere. Slide. Staff adopted the BCTT process definition for seriously interfere as, does the proposed use make it difficult to continue uses on the adjacent property? Would it create a significant disruption to the character of the area? And or would it conflict in a substantive way with the proposed zone? Next. The second term, uses on adjacent property. Slide. The code does not define adjacent. The applicant defined adjacent, and we concur with their definition, the applicant says it started with a base site that includes all the tax lots on which the existing landfill operations and accessory uses are located, plus all the tax lots constituting the development site on which the project will be located, or the landfill boundary. The applicant then identified properties abutting the landfill boundary and the properties abutting the adjacent properties. So basically, it's the landfill with the adjacent properties, all the properties that they own, and the adjacent properties to the properties they own. So that is their defined area here. Slide. The third and final definition is the character of the area. Slide. According to the application in Exhibit E10 of the staff report, the BCC 53.215 character of the area, this is from the applicant, and the graphic is also from the applicant's application, is 90 square miles, both rural and urban, resource land, has varying topography and natural habitats, and, quote, occasional odors, sounds, noises, and trips from the existing landfill operation and surrounding resource extraction uses. Slide. The third and final term is the purpose of the zone. Then the purpose of the zone is that there has been a waste disposal site here since 1948, and that became an allowed use in 1983, I believe. And there have been 2 subsequent expansions and a denial of a 2021 expansion proposal. Slide. (53.215), the purpose of the zone, there's also land within this area that's forest conservation zone. Slide. Page 26 of your staff report includes an engineering analysis by MFA, and they can go into some more detail on their analysis and conclusions. But in short, the applicant identified the closest noise-sensitive properties and evaluated potential noise impacts on their uses. The applicant did not evaluate noise impacts on other adjacent properties at greater distances, and staff agrees with the applicant's reasoning about this, because if noise doesn't seriously interfere with close noise-sensitive uses, it's not going to seriously interfere with uses that are farther away. And the applicant also addresses DEQ noise requirements in this section. We also agree with the applicant that the DEQ noise rule does not appear to be directly and entirely applicable to the proposal. Further, staff concurs with the applicant's use of that DEQ regulation to set a threshold for the noise increase to seriously interfere with noise-sensitive uses. However, as noted in the MFA findings, the proposal appears to exceed the DEQ regulatory noise threshold proposed for the use to evaluate consistency with this standard. The proposal does not meet that criterion, and therefore, because there's an absence of a solution, staff recommends this may be a basis for denial. Slide. Beginning on page 27, again, evaluated by our consultant, the applicant was asked to develop an odor analysis. While the findings of the applicant's odor model do predict the odors generally would not be considered an odor nuisance, MFA observed several inconsistencies in the model setup that could significantly affect the predicted values. Odor is tough to analyze. However, staff appreciates, staff appreciates the evaluation and the evolution of the applicant's odor analysis. They've worked on this for 9 months now. And for example, there are 18 different people. 18 different people have different levels of sensitivity. There's weather systems that produce different odor patterns, and there are many sources of odor, but there is a science-based method of evaluating odor, and odor levels can be quantified. Therefore, staff places high value on technical analysis in relation to the odor produced by the proposed expansion, because the applicant's conclusion relating to the odor levels is relatively low. However, there are a couple concerns. The analysis does not appear to identify adjacent uses that are likely to be more sensitive to the odor impacts. For example, a residential use is likely to be more sensitive to odor impacts than a farm field. Locations of odor-sensitive uses are not clearly defined in the odor analysis or the mapping, and the potential impact on these uses is not specifically evaluated. In particular, there may be odor-sensitive uses within the boundary area of their analysis. We're not sure. Second, several technical elements of the analysis appear to be inadequately supported. Due to these concerns and the lack of options for conditions to mitigate, staff recommends this to be a basis for denial. Slide. We're moving on to traffic, groundwater, and visual impacts. Staff concurs with the engineering and transportation comments, as well as the applicant's conclusion. The transportation impacts from the proposed expansion are minimal and are not expected to seriously interfere with adjacent land uses. Again, we did receive comments from ODOT today, and we have not had a opportunity to comment on those yet or review those comments. Slide. Okay, staff understands that in regards to groundwater, staff understands that groundwater impacts have been an extremely controversial topic. However, the county is limited in its ability to evaluate and regulate groundwater impacts beyond the multiple levels of state and federal regulation that apply to this proposal. We made several legal inquiries, and yet our position remains that those regulatory agencies provide a more appropriate venue to address groundwater impacts. That said, staff concurs with the applicant's analysis and engineering comments. So for purposes of county review and in the context of additional required regulatory frameworks, the proposal meets this criterion. Slide. Staff concurs with the applicant's findings in relationship to adjacent properties. While some elements of the project are visible, as of the writing of the staff report, staff has seen no evidence or reason to conclude that the visibility of some of the elements of the proposed landfill expansion from the adjacent roadways will seriously interfere with the uses on the adjacent properties. The character of the area, on the basis that the character of the area is that it is a landfill. So it's not having much more of an impact because the character of the area is already a landfill. Slide, you can. And in regards to the forest conservation zone, on page 45 of your staff report, staff generally concurs with the applicant's response. The standards contained within the forest conservation zone directly implement the purpose of the forest conservation zone by evaluating and limiting impact on the forest uses, by addressing fire risk and regulating the site development to limit impacts on forest resources. Staff evaluates the applicant's consistency with this requirements under Chapter 60 with those findings. The findings in BCC 60.2201C that requires consistency with 53.215. And since we don't believe the criteria to be met with respect to noise and odor impacts, the proposal also does not consistent with the purpose of the forest conservation zone. And so the applicant states that the proposed shop maintenance building is located on tax lot 1200. Staff could not identify the proposed shop structure that's on the exhibit E2 sheets 5 and 6. And because it's not identified clearly, we're not able to evaluate it, and therefore it's not meet the basis for evaluation. And so this too could be a basis for denial. Slide. On page 55 of your staff report, proposed employee building on tax lot 1101, proposed maintenance shop area building, it's on tax lot 1200. And we could not identify the proposed shop structure, and so that standard is not met. Also potential basis for denial. Slide. And beginning on page 64 of your staff report, we have general development standards. Again, not an area of emphasis here this evening, but those do include the development activities in wetlands, road design, construction standards, erosion and sediment control, post-construction, stormwater management, and sewage disposal. These are things that are more rigorously looked at as you go towards actual development. And we do have Public Works here that can answer more specific questions here, but we do not have any concerns in this area. Slide. So that's the conclusion of the staff report based on the findings In the report and the information in the file, staff concludes that the noise and odor analysis and evidence provided by the applicant does not sufficiently demonstrate that the proposal will not seriously interfere with uses on adjacent properties or the character of the area. Therefore, staff recommends denial of this application. Thank you very much.
Thank you, Ms. Sheets. I appreciate that. And as has been noted, I think we've all been tasked with reading over 3,000 pages of material. And this is our opportunity for fact-finding on that material. And we'll now offer each of the planning commissioners the opportunity to ask questions regarding the staff report. And so we'll afford that opportunity to each commissioner in turn, beginning with Commissioner Biscoe.
Thank you, Chair Fowler. Is that working? Thank you. I have a couple questions for staff. First, I do want to thank you for an extensive application. The 3,000 pages and the materials that are in there have been very helpful in this review process. The staff report was also very helpful. I want to ask, maybe this is a chair question or our planning department. Are we allowed to ask questions for things that were not addressed in the staff report, but are within our bounds of criteria and code? So if I have a question on chapter 77, for example, can I ask that question even though it wasn't addressed in this? Yes? Okay, for clarification's sake, that's helpful. So I would like to refer to that chapter 77 if I could. And when we look at Benton County's code, 77.205 talks about prohibited uses. And this goes to a question that was raised during Benton, the BCTT process. There were questions asked. I'm not certain if there were answers that were provided. And so if they have, if you can help me understand where they are so I can review them. This particular one, 77.205, number 1, talks about hazardous waste disposal. The question that was raised during Benton County Talks Trash was what types of hazardous materials. I'll step back. Toledo had experienced a train derailment, and in that case, that hazardous material was brought to our landfill, the Coffin Butte landfill. The question was, under what circumstances would that occur? And as it reads here, that would not necessarily be allowable. And so I'm wondering if that is something that we got information or context on through that BCTT process that was provided, and or if it's in this document and I just haven't found it yet.
Okay, yeah, so we did not dive into that question in the staff report or in the materials.
And would you mind telling me again who you were?
I'm Jesse Winterode with Winterbrook Planning. We look at the staff report as contract staff planners.
And that was not addressed otherwise then, so between Woodbrook and also Benton County. Okay, so the hazardous materials question, perhaps I'll bring that back then to the applicant. I'd like to point to page 19 of the staff report. For some clarification questions. We talk about adjacent property and the interpretation of the applicant response of adjacent property is from Webster's Third New International Dictionary, defining adjacent as not distant or far off, nearby but not touching, relatively near and having nothing of the same kind intervening, having a common border, abutting or touching, living nearby or sitting or standing close, relatively near or close together, immediately preceding or following with nothing of the same kind intervening. In the staff report, what I heard, but correct me if I need to be corrected here, we were talking about the landfill properties of ownership and then also those abutting properties. When we talk about adjacent being somewhat an ambiguous term here and being defined here, at least in this case by the applicant, do we also include those adjacent properties such as the residential areas immediately around the landfill? Yes. Okay. So yes.
It was, hopefully we can see on the map, a pretty inclusive definition of adjacent.
Okay. And would we also then include the properties across 99W, which would be part of a DARE as well? I actually can't.
Yes. Oh, sorry.
Can't see that very well from here. Okay. Thank you for that clarification. I will also go back to another part. I don't have the page in front of me, but it's in information I was reading today. We were talking about the Solid Waste Advisory Committee and their reporting, or that shifting of reporting going to NRAC, the Environmental and Natural Resources Advisory Committee. Have we in this document, and just not got to it yet, have we any reports? We're supposed to receive an annual report, correct?
Yes, so SWAC submitted a document that is part of the record, and NRAC also did. DSAC submitted a document that was 40-some pages long, but SWAC did not, because they're not no longer part of that division, I guess. The duties were transferred to NRAC, and NRAC submitted a 20-some page document the day before our staff report was due, so we did not include a full review of that document in the staff report, and we intend to update the staff report with that document in mind and respond to the issues raised there.
Okay, and to clarify, so we'll see that update in when will we see that report?
So we're trying to include the comments that we're receiving in this process, as well as the full weight of agency comments, such as the ODAC comments received today and the NRAC comments. So after the public submission of information is done, then we will update the staff report prior to your deliberation so that you'll have that deliberation.
All right, so that answers the question of when we'll see those documents. I'm going to go back and just clarify so I understand. So there's an annual report, and there's also submittal for this testimony, and there are also opportunities for maybe NRAC now to weigh in on land use applications. I feel like there are 3 different portals of which we should be receiving information. Am I reading that correctly?
The code identifies 2. And one of those was replaced with NRAC. So we should be receiving 2 and not 3.
Okay. And again, for clarification, excuse me, I just want to make sure we have this right as we move forward. We will be receiving comments. Do we have the annual report that's also required by code at any point? So we had the shift from SWAC or DSAC, forgive me for not knowing which one, but one of them was to submit an annual report on the Coffin Butte landfill. Do we have that as part of this record, and or have we received these?
They are complete. They have been endorsed by the respective, by DSAC. And so they are up to speed, but it is not part of the record this time. And just a clarification is what we did is we considered NRAC an agency referral partner, and we're considering DSAC as public comment.
Thank you. That helps refresh what I had read. Okay, so will we receive that annual report, the most recent? Can that be submitted for this record, or can it be requested?
Thank you. You're requesting the planning staff to add the NRAC annual report, most recent annual report, to the record.
It's not NRAC,
DSAC.
right?
NRAC or DSAC?
I think it's DSAC, right?
Okay,
yeah.
so DSAC is a statutorily required agency. It is not a county code originated body, not an agency. I don't really think it's a problem to add that DSAC report to the record, and I believe DSAC's report is already in the record. It just wasn't received before the staff report was published. Do I have that right with the Winterbrook?
The annual report that they work on is not in the record. However, their comments are in the record.
So thank you, and thank you.
Yes.
Could we add that report? If I'm requesting that, can we add that report for the record? The annual report, not the comments, right?
Yes,
Two
it can
different
be in the
things.
record.
Yes. And is that a 2023 or a 2024? The annual report.
24.
Okay. Okay. Another question I have is we have a committee for citizen involvement by code, the planning commission, I think it's in the general code chapters, excuse me. Planning commission serves by code as that citizen for a committee for citizen involvement. It's part of this Oregon's land use laws, right? So number one, our first land use law. I'm not sure that we have officially talked about that since I have been on the planning commission, which was January 1 of 2023. And I am curious how we are representing that Oregon's land use goal number 1, but also what was the citizen involvement program? So it's not just an identity that we hold here on the planning commission, but there's also a program that is supposed to go with that according to our code. That program serves as a purpose for the kind of a liaising, if you will, to the community on inclusive of land use applications, this one being significant by evidenced by the interest in our community. Do we have any record or documentation of things that have occurred that I may have not been aware of in this process of meeting that CCI program requirement to liaise with the community on land use, in this case, this application?
Commissioner, thank you. The application before the commission tonight is to be decided based on the specific criteria in the code. I'm having a little bit of trouble identifying the Benton County Code criteria that apply to the conditional use application that would bring in the CIC issue that you're talking about.
Thank you. Could you state your name again? Because I...
Yes, Miss Melissa Ryan, and I'm Special Land Use Counsel for the county.
And I appreciate that. So my understanding is that we're talking about all of the code chapters that were referenced here. That was part of that code chapter. And being an essential part of land use, the processes that we follow, it seems like that's relevant to tonight. Even though we are talking about criteria, we're also maintaining a decorum and a process requirement as to how we do this land use process. So that was my question. Is it possible to have that question answered? Do we have any evidence of a CCI here in this process? It's been a very lengthy application process, as we know.
Commissioner Bisco, Chair Fowler, again, I'm not, do you have a specific code reference that you're looking at in the applicable criteria for this conditional use permit application? Otherwise, I'm not following, and perhaps that after the applicant's presentation, we could potentially take this matter up again.
I am looking. I will say that, let's see, it appears to be. Well, it's number 4. It's in one of the chapters that are listed on the front page of the staff report. It says the Planning Commission shall serve as the Committee for Citizen Involvement, or CCI. The CCI shall assist the Board of Commissioners with the development and evaluation of Benton County's Citizen Involvement Program as it relates to land use planning. The CCI shall conduct an annual review of the Citizen Involvement Program and report the findings to the Board of Commissioners. My understanding from our Department of Land Conservation Development is that goal number 1 is our number 1 goal for a reason on citizen involvement in public hearings, land use applications. In this case, it is in the chapters that are referenced on the front of the staff report. If we don't have any answers, I'm happy to move on. But it's a question that I would like some follow-up if we have that opportunity as to whether or not we have engaged with a committee for citizen involvement and its roles and relationships with this process. Give me a moment. I'm going to scroll through my notes here to see if there are any additional. I do not believe I have any questions additional at this time, Chair Fowler. Thank you. And thank you for the clarifications.
Very well. Moving to Commissioner Cash. Do you have any questions?
Sorry, I'm having a hard time unmuting. I don't have questions at this time.
Thank you very much. We'll move to Commissioner Fulford.
Hello, thank you. I do appreciate Petra, the staff, putting in all the good solid work on the staff report. One of the concerns I have, I know we flagged the noise side and the odor side, and I know we referenced sort of the EQ and EPA as being more in charge on the groundwater piece. I think there's a ton of risk in that area, obviously with the leachate going up and down, or a 100-year storm or something like that overflowing. Do you all have some concerns about that? It seems like we left that off of, I'll say, one of the denial pieces, and I still have considerable concerns and the risk on that side. What are your thoughts on that?
Thank you, Commissioner Fulford. So as Petra said, we don't have a lot of the technical capability to review leachate, underground pollution impacts on surrounding areas. That's very difficult for us to do. But we did have engineering review of the application and of groundwater, stormwater. So we took a look at that and got responses from our engineers on best practices and the proposal. And what they found was they didn't have concerns from an engineering standpoint on that. And as planners, we looked to the engineers to provide that feedback.
So follow up on the PFAS stuff that comes out, right? That both Salem and Corvallis struggled with pulling that out based on their wastewater treatment plan and their aging of that. Is there been any look at, I know Dare Village is looking at, I think it's HB 3939, new wastewater, more advanced wastewater. Is that been in scope, or have y'all thought about that at all? Because that seems like a solution waiting to happen, at least address the wastewater piece.
I believe we have some of our engineering consultants online here that maybe we could get a more direct answer to your question on what they looked at and how they're looking at that question. Okay. Ellery, are you available?
Maybe fill in time while he's
finally was able to unmute. I apologize. It looks like I was locked out there. We did not evaluate anything related to Dare Village. The applicant noted that they had existing agreements with Corvallis and Salem.
So something probably to note, there is a current bill that's in good standing. It's HB 3939, which would take the PFAS out. And I saw quite a few of the letters saying, hey, when I float from Corvallis down to Salem, it's not a good place to be, right? So I think that's probably it on my questions. Thank you.
Very well. Let me move then and invite Commissioner Lee if you have questions.
Thank you very much. And I repeat all the appreciation for all the work that went through this. So I have several questions, and I apologize, they're not in any rational order. There's Benton County Code 77405 that suggests that the planning official needs to be reviewing all the reports that come from DEQ related to the application, and I interpret it as any reports from Oregon DEQ regarding the landfill. So I'm wondering, I wanted to ask Petra, were you the were you hired as the planning official? Have you ever been the planning official? Or is there a planning official in Benton County?
I am the planning official, yes.
Okay. And is it in your job description to review the reports from Oregon DEQ about the landfill?
In my job description proper, no.
So essentially, thank you. So my next question is kind of a broad question, a concern. A lot of our code and a lot of the regulations that are referred to in the application and in our code refer to federal laws and agencies, and we're in a period of enormous transition. And I want to know what is being planned. So for instance, if the Clean Air Act went away or the Clean Water Act went away, what is the plan for that? And I'm going to ask the applicant, how will they behave if suddenly the Clean Water Act goes away, or the, the Environmental Protection Agency lab that is being used is gone? What's going to happen?
I'm not sure of the relevance of the question. Very important question, but I'm not sure the relevance of the question to the hearing this evening. I'm not sure we could address it.
Okay. Oh, thank you. Okay. I think my other questions are for the applicant. Thank you.
Thank you.
Thank you. We'll now invite Commissioner Struthers for questions.
Thank you. Petra, thank you for that. I will not touch the mic again, I promise. Apparently, if I touch it, it's a little warm here today. For your reports and as well as the consultants for helping you. I think my first question is more of a procedural, just trying to wrap my head around the land use application itself. Looking on page 8 of the staff report, there's what's considered the subject property of 462 acres of the whole area of the landfill. But we're specifically for this application are only focusing on the 5 tax lots and those specific acres, and that's the only thing we're evaluating for this criteria. Is that correct?
No, it's actually the entire area that we showed with the map, because the significant impact area, for example, with noise and odor, extends beyond the expansion area proper.
Okay, thank you for that clarification. That actually does help wrap my mind around what we're looking at here. My next question, sorry, I didn't write down a page number, I apologize, is related to the noise rule with DEQ. And in the staff report, I'm looking at the wrong set of notes here, apologize. On page 22 of the staff reports, there's a footnote from the applicant's burden of proof, and this may be a question back to DEQ or to the applicant, but it makes a note that the DEQ doesn't enforce its own noise rule. Is that back to the governmental body like the county to enforce, or is that unknown at this time? And the footnote with, I think it's page 22, if I have it. It's a little footnote that says 40 right next to it. Yeah.
So we have our noise consultants online.
Oh.
And Ellery, could you respond to this question?
I can jump in on this. This is Bill Beatty at Mall Foster. And I evaluated the noise report. My understanding is that DEQ lost funding for the enforcement of the noise rules. So while the noise rules are still on the books, they're still there for reference. Many years ago, DEQ lost funding to have a department that goes out and enforces those noise rules.
Okay. And so there is nothing within that rule then that delegates it back down to the governmental body that still resides with DEQ, if I'm interpreting what I've heard.
As I understand it, there are some local jurisdictions that have people that enforce those rules, different cities that may have adopted the DEQ rules. There, as in the same way there are model codes that can be incorporated by reference into local codes. I apologize for not being sure if Benton County has an enforcement of the DEQ rules. I don't believe so, but someone from the county can set me straight if I have that wrong.
We do not.
And then my last question, at least for now, there was some comments, I believe it was in the staff report. There's a lot to consume, so I apologize if it wasn't particularly in the staff report. But around the hours of operation, but I guess my question, knowing that we're not looking at conditional conditions of approval or additional conditions of approval at this point, but with the hours of operation that are currently in use or recommended, do staff have any issues with those hours of operations that have been proposed?
Yes. There's some conflicting information presented by the applicant on the hours and proposed hours of use and their proposed conditions. And I believe they're going to clarify some of that in their testimony.
Perfect. That is all I have then. Thank you.
And moving to Commissioner Wilson.
Thank you, Chair Fowler. And I'll turn my microphone on. I wanted to thank Petra and her staff. The staff report was put together in a way that made it easily digestible for me. And I also want to commend that in this instance, going in this order, all of my prior commissioners have asked almost all of the questions I had on my mind, except I wanted to come back to Commissioner Fulford brought it up initially. Excuse me if my allergies are acting up, so I'm going to sound like a frog. The water, the issue with water, groundwater, and first let me clarify: is it my understanding that the county using our code, the groundwater issue is one that isn't necessarily is not one of the reasons, is a criteria that is either is met or not met because it's a matter that's dealt with outside of the county's jurisdiction?
Correct.
And with that in mind, when you were evaluating or had the consultants do the evaluation of the groundwater issue, did they make a distinction between groundwater flowing either underneath or through or past the landfill, the existing landfill, versus percolate, or that percolates through the landfill and then potentially intermixes? Because and it's a question I might offer to the applicant, but it wasn't clear to me with regards to leachate, which is the effluent from the landfill itself, which percolates through the landfill, what the capture rate is on that. And it's in that groundwater discussion, it's not in that section. So it's just a question as to whether that was an issue that was considered when looking at the groundwater issue itself.
So I would defer this to our engineers who are reviewing the groundwater item.
Well, we did look at the leachate specifically. The groundwater, as Petra mentioned, is difficult to address. Note that there is an unlined portion of the landfill that does still operate to our knowledge. However, the rest of them are all lined, and this existing or this proposed expansion is proposed to be lined so that the leachate is fully captured and treated.
And it would be safe to assume that with this expansion, there would be an increase in volume of the leachate?
That would be a correct assumption. Additional leachate is generated as you expand, and as portions are closed, that would tend and capped, then that would tend to stop generating leachate.
So that the areas of the landfill that become closed, capped, and sealed, those no longer generate a leachate runoff as opposed to the areas that are still being used?
It's a process basically as the leachate that is within the landfill material slowly makes its way down through the bottom. So there is, even after it is closed, generally landfills will continue to generate leachate, although it diminishes over time. Hopefully that makes sense.
It does. Thank you. And I have no other questions, Chairman.
Thank you. Vice Chair Hayman.
Thank you, Chair Fowler. Again, thank you for the report and I think a very informative conversation for my part. I have just one question, and it may be articulated in the report that I perhaps didn't pick up, but the primary issues that you've noted for a recommendation of denial are odor and noise. And I guess what I'm trying to understand is, at least it's my perception, that these conditions already exist. And so can you help me to understand how those issues play into the consideration of this application?
Thank you. That's a great question. We looked at this as the expansion is under review. The existing conditions are somewhat of a baseline. And so what we asked of the applicant was to show us exactly what the expansion is creating in terms of noise and odor, and map that and provide technical analysis related to that. And we brought in our technical experts to review their work. And so that's what we're looking at. We're not looking at adjudicating the existing landfill in those respects. So the noise and odor are based on the new landfill expansion area.
Thank you. That's very helpful.
No more. Okay. Batting cleanup. I do have a few questions, and I'll apologize in advance that some of these may be staring me in black and white in either the application or the staff report, and I may not have just picked them up. And some will be probably best answered by Ms. Ryan. But so, I'll ask many of these, both of the applicant and the staff. I'd like to get their perspectives on both. First is, how should we read the statements in the application? Are they commitments? Are they statements of direction, subject to change? How firm? And I'll just give an example. The application states that there will be only one working face at a time, and operations will be roughly the same scale. So I'll come back to the applicant during that presentation, but to the staff, how did you take the application's statements into consideration?
That's another good question. What we would typically do is assign conditions of approval related to the scale and the time and all of the elements of the landfill operation that we intend to regulate and restrict. In this case, we were recommending denial, and rather than sort of throw out confusing statements of, if you are approving it, then these conditions or not, we went with, we recommend denial, knowing that we will have another staff report as well. And if we get information that responds to all of our issues and we have a situation where we can actually assign conditions of approval, then we will have a host of conditions of approval that are related to restricting what's happening here. So what you don't see is that host of conditions.
Well, and I'm going to wade right into that. Okay. Because I am sure the applicant is going to try to persuade you to change the staff report to a recommendation of approval, and they're certainly trying to persuade us to approve. And so I've got a number of questions around hypothetical considerations of approval, knowing that these have not been proposed, they're not on the table, but they, I think, are important to discuss. And so, for example, we see that Republic Services and Valley landfills are used somewhat interchangeably. So what is your understanding of the relationship between the two entities? And who will hold, if we assign conditions of approval, who will hold those conditions of approval and who will be held accountable?
That's a very interesting question. We have an applicant that's Republic Services and a property owner that's Valley Landfill.
And I would mention that their October submission actually has Valley Landfills as the applicant. So I'm a little confused, and maybe it's a distinction that is immaterial, but go ahead, please.
So we would assign these conditions to the use, and they would go with the owner.
With the property owner.
So the owner of the use would have to comply with the conditions of approval.
Okay, so it's the property owner that would be bound by the conditions if approved. How would transitions of ownership be handled in terms of either a sale of Valley landfills or an assignment, or if I understand Republic Services is a public entity, so a significant restructuring of a public entity? When does a condition of approval get lost in a transition? Yes.
It runs with the use.
So as long as the use is active, it will run regardless of entity?
Yeah.
Thank you. What if this, I probably obvious, what if operations are outsourced? It retains then with the property owner, and the property owner remains responsible regardless of the outsourcing of operations.
Yeah.
What if there's a bankruptcy?
That's an interesting speculation. Yeah, I can't really get into the speculation of what will happen after, if there's a bankruptcy here.
Does, and I'll look at Ms. Ryan, does a bankruptcy dissolve
Thank you, Chair.
obligations?
That is a complicated question. I am luckily not a bankruptcy lawyer. I can look into it and get back to you at the next meeting if you want, but in bankruptcy, I do remember that there are ways to discharge some obligations. A bankruptcy trustee would be overseeing that entire thing. I did want to note one thing that I have seen some jurisdictions do to make certain that conditions of approval that are placed on an approval are known is to record a notice of the land use decision in the property records so that it comes up on a title report and a future owner then is made aware of it.
Okay, thank you. And a landfill's a unique situation because we generally look at a business operation having a beginning and an end. And while deposits into a landfill may end, much of the other surrounding infrastructure needs to continue. So how are conditions of approval that we may or may not impose, how is operations defined so that it continues beyond the deposit period in a landfill?
I think that is in the realm of the legal expertise.
Not Chair Fowler, I'm not entirely understanding your question.
I've seen in the past where a planning commission has imposed operating conditions, but operating conditions require a definition of operating. And in a landfill, does operating mean continuing to deposit solid waste? Or does it, once it's been capped, sealed, whole thing is done, some of those conditions we may desire to persist into the future? How would that be handled?
I think the county has a lot of latitude in how they phrase conditions of approval, should that be the direction that the planning commission goes to address that potential problem.
Okay, so there are options available to us. So code sections 53.220, 99.905, and 99.925 provide the potential imposition of a bond to ensure compliance with conditions of approval. At least during my tenure, I don't recall that ever having been imposed by the county. And so, Ms. Sheets, could you describe what that process is?
It's generally for the actual, before the actual development of the property to ensure that the public improvements are completed. So I don't know what the history here at the county is, but I've seen that done regularly in other jurisdictions.
And in that case, similar to an operating condition, can that bond be held beyond the development site and into operations, essentially, as long as there is the risk of an externality?
Maybe another legal question.
Thank you. I believe, again, it would be up to the county with some discretion to determine that. The applicant, of course, is involved in conditions of approval and can object to them and can potentially then accept them and then go and challenge them either in circuit court or at LUBA. But it is possible.
Thank you. I see three governing processes happening, some in synchrony, some out of synchrony. So there is a DEQ permitting process. There is this conditional use process. And then there is a franchise agreement that the county has with the applicant. How do they interrelate? Where are the boundaries? Where are the overlaps?
Do we have the county's attorney here to speak to that issue?
You know, I did get a little rundown on this. So the franchise agreement and the land use process within the county are not intertwined. They are separate because the land use process is driven by the development code. The DEQ process is separate. It's its own separate process, but the county has given itself in 77405 a separate way for the county as a body, as a government, to provide comments in that DEQ process through 77405. Hopefully that answers your question.
So there were two of us that were a part of the previous application process, and this question came up in the previous application process as well. And I think we got a similar answer, which quite frankly makes me uncomfortable because we have a DEQ process where perhaps the Planning Commission has no say whatsoever. It's the county that could offer content. But the externalities associated with the landfill, such as methane, which came up in public comment and a number of other places, we don't have any way of evaluating, monitoring, regulating, controlling, even though it is a significant component of a land use decision, because it would affect the surrounding properties. So it makes me very uncomfortable to have not even any input to a DEQ process, much less any control. And we do our part and then we're done. We don't get to then look at the DEQ results and come back and revisit our land use decision. And this is more of a soapbox than it is a question. That makes me very uncomfortable. We won't see the result of the DEQ process before we have to make a land use decision, even though they're very, very intertwined. But again, soapbox. Moving on to a question of the county. I believe the county has climate goals that it intends to implement. I confess I'm not very familiar with them, but I believe there are some climate goals. And this gets back to the DEQ process because I don't understand the mechanism to implement those climate goals unless there is some county control over things like the greenhouse gases associated with a land use opportunity. So, Ms. Sheets, would you like to comment on what the county climate goals are and how it would relate to this particular land use application?
Particularly familiar with them. It's not necessarily directly in my line of work, and it's not directly related to this land use application criteria. So, I'm not sure what, I mean, surely there's correlation, but it's not relevant to this hearings process.
Okay. It appears as though you're itching to also offer.
Sure. There are ways to bring the climate goals into the code so that we can and you can review them against applications. And that is my understanding. It hasn't happened yet.
That is true, although some of those exist in our comprehensive plan. And certainly the comprehensive plan compliance is within our opportunity to discuss as well.
I will go ahead and take that one. So the Benton County Code, Development Code provides the only review criteria. The comprehensive plan is not a review criteria. The comprehensive plan can be helpful to inform interpretations of ambiguous code sections.
Exactly.
But it doesn't apply directly to this or any conditional use application.
Right.
And
It is not code. I understand
Yes.
that, but in terms of having it as a context to define
interpret-
some of these terms that are not defined,
Yes.
that's perfectly within our realm of.
For example, you're going back to your question about how would the county define operations, the length of operations. I don't know, but perhaps there's something in the comprehensive plan that could guide that crafting that condition of approval.
Right. We've had some terms thrown about, and this is my ignorance more than anything else. We have a DSAC, a SWAC, an NRAC. I guess SWAC is no longer extant. What are they, and what roles do each play?
The SWAC was the SWAC was a requirement of the disposal process, but it was dissolved while they went through the Benton County Detox Trash process. And the Board of Commissioners then put that on a hiatus, and for the land use process then designated or used, continued with DSAC, but designated NRAC, the Environmental Committee, to fulfill the SWAC responsibilities for this application. So that's that relationship. The disposal site committee is specific to the operational concerns of the committee and representing the community, and it also includes representation and membership of Republic Services. So it's aimed to be a partnership to work through concerns at the landfill site. So those are those different roles. At some point in the future, we'll probably reinitiate a SWAC, but at this time it is still on hiatus.
And I mentioned earlier this evening that one was considered an agency referral and one was considered a public comment. Which falls into which camp?
Yeah, so NRAC was the one that was appointed by the board to fulfill SWAC's responsibilities. So the closest responsibility or role, since they're more than public comment, seem to be classified, in my opinion, as more of an agency referral comment. So that's why they received agency referral notice and was classified that way. They were treated a little bit differently. We needed to give them some training on the land use process and the criteria and what that means, and put some sidebars. And so those are all meeting minutes and, agendas that we may add into the record. That's also been a question, so that folks understand that we were, above board in terms of the guidance that we gave that committee. So they did a lot of work. I think they met 4 or 5 times and really worked hard on their response. So we really appreciated their efforts. DSAC on their own were interested in the topic, and even though they had not been appointed with a formal role, they chose as a committee, and because they had the ability to do that amongst themselves, decided to provide public comment as a committee or an entity. So they did provide that as an entity.
Great, thank you.
Chair, just to clarify, the DSAC is a statutorily mandated committee, and it's because Coffin Butte is a regional landfill. So it's not a county generated or county sanctioned committee. It's a statutory committee.
And that statutory committee is because of the regional nature of
Because it's a regional
landfill,
landfill.
and that designation occurred, in 1974. The code wasn't updated until 1983, but I don't see anything in the code, and I may have missed it, but I see nothing in the code about regional landfill. And so from a land use perspective, from a code perspective, regional landfill is what?
It's the statute that defines the regional landfill. It's the statute that requires a DSAC and sort of specifies the composition, including having a member of the landfill operator on it and some other folks. And the statute defines regional landfill, but I don't have it at my fingertips.
Right. But we have nothing in our code
That's correct.
that has regional landfill. There's no discrimination between landfill and regional landfill in Chapter 77.
But there will be when we get to the second phase of our development code update. So it is on the list.
I very much appreciated the circle chart with all of the public comments. I attempted to read all of there were nearly 3,000 pages just of public comments. And so that was impressive. And I think the circle chart does a very nice job of summary. But as I reflect on those 3,000 pages, there are a couple of overwhelming themes that seem to speak directly to some of the concerns that were expressed in the staff report. Yet none of the public comments entered into the analysis portion of the staff's report. And I recognize, for example, with odor, our public doesn't have the instrumentation other than their noses to be able to quantify something. But I guess first answer, if you would, why that public comment wasn't considered as a part of the analysis.
It will be. We wanted to make sure that we continued to collect through the record. And so the subsequent staff report will have a more thorough analysis.
Okay, I would hate to lose all of, or just leave it as the public comment is there for us to digest. I would very much appreciate that the staff report incorporates some of that very valuable information that was submitted.
And if I could add, there's some concentration points that we're working on as well that we'd like to. So for folks that live near the landfill Landfill, for example, we're specifically interested in their comments around odor, and we'll do a spatial analysis and comparison on their comments and weight those comments differently than odor concerns from folks that do not live in the vicinity of that. So you'll see a variety of ways that we approach those different things in a demographic and spatial way.
Thank you. I look forward to that. What is the property tax structure of the tax lots in question? I don't know anything about the property tax structure of a landfill zone, whether it's similar to a resource zone. How is it assessed? Is it county assessed? Is it part of the state assessment process? How are property taxes calculated and realized on this property?
It's county assessed. I know nothing more.
Okay. It also seems unusual. You know, we have a zone that's exactly one set of tax lots and never will be any more, I don't think. And it's an unusual situation where I imagine this property is very valuable during the depositing stage and not very valuable once it's complete. And so but that doesn't mean that the county burden associated with that property changes in the same way that the property value changes. And so as we evaluate things like undue burden, how do we assess the mechanism by which tax revenues are collected for things like fire service protection throughout the process? Because I imagine that the fire service is supported through the property tax collections of this particular property, as they are for all of us.
Are you asking how does the value of the property impact the associated districts?
Well, I'll use fire service as an example. I think we do have a letter from the Adair Fire Service. I believe they are supported exclusively through property tax revenue, and I would appreciate asking them if that is accurate. The landfill poses a unique risk for them to manage. I imagine there's specialized training associated with landfill operations and so forth. And I'm just trying to balance what are the collections versus the public burden of offering fire service.
That's a very interesting, it's a really interesting question. Actually, I really appreciate it. We haven't delved into that, and we can ask for more feedback on that issue.
I would appreciate it. And it's probably not the only example of public infrastructure that is impacted by this unique property. And so I would encourage us to look at more than just the fire service, but that seems to be one.
Chair, if I may, this might be a good topic for the applicant as well.
As I say, most of these questions are going to be asked in a bit of the applicant in addition. Moment on character of the area. The BCTT information interprets area to include, as one of the bullets, the likely extent of effects of the proposed land use. That, I think, is broader than the abutting and the adjacent properties. And what we've seen in the public comments, if there are any indication, the area used in the application and staff report might be too restrictive based on what the BCTT includes in the definition of area. Adair Village, with the support of the Benton County Board of Commissioners, expanded their urban growth boundary largely to the south, but also some parcels in the north, which are getting closer to the landfill site. How did you assess and accept the definition of area for character of the area, and why did you exclude something broader when the impacts are clearly experienced outside of that zone?
So we did have two areas that we looked at and the application looked at as well. For adjacent properties, that was the properties that were next to the landfill. For character of the area, we had the applicant provided a 90 square mile area that included the extent of reported odor impacts. And we thought that was a quite large area to evaluate the character of. I would say the difficulty in this evaluation in terms of character of the area is that there is an existing landfill and we're evaluating the impact on the character of the area for the expansion of that landfill. And so it's a complex sort of question.
This whole application is complex, and we appreciate that. So thank you. And I want to build on that a little bit in terms of current operations are considered kind of the base case, and then we build on that. And obviously, this is really a scenario. And we've looked at the landfill operations as a base case, but the character of an area is dynamic. Just as the landfill operations have doubled in size since 2017, if I read the report correctly, I'm wondering what's happened to the surrounding use areas over that same time. So if we accept the character of the area that it includes a landfill, but over that same 8-year period, what's happened? And I guess I would focus on residential applications because that's going to be most sensitive to expansion of a landfill. What's happened to the residential area in that same character of area analysis area?
That's a good question. I think one of the important things to keep in mind is the objective of the analysis and our constraints on looking at what the proposal is versus what has changed with the existing landfill and what has changed around it. And we're looking at, will this expansion seriously interfere with the character of the area when the character of the area, as you're saying, has changed over time, and so has the landfill over time, and we're looking at just the expansion. And so it's hard to get to an answer of what makes a difference in the character of the area to an extent beyond people who are concerned about and have reported impacts from the existing odor. That I hear what you're saying, and I'd say it's difficult to establish that distinction.
Well, and I would add on to the complexity, but I think it's important in that when we look at approving an expansion, okay, we know what that expansion looks like, but what is happening to the area as well? We know that area, so can you project as a scenario 10 years into the future? What does the surrounding area look like 10 years in the future? Because I think we should consider impacts not just today and one variable changing, which is a landfill expansion. There are other variables that are changing as well. The surrounding area is changing. And so as we evaluate impact on the area, both ends of the equations kind of need to be spun forward in a scenario.
I appreciate the thought and that idea. It's just beyond the scope of pretty much any land use application I've ever seen. So I think it's a great idea, but it's just not something that applicants or staff really evaluate.
Okay. And if I can jump in, I think that the reason Jesse's saying that has to do with the goalpost rule, which gives the applicant protection from changes in the law as of the date their application is deemed complete. It doesn't give them protection from changes in fact, but the way that land use applications are processed is to sort of take a snapshot of the lay of the land at that time, unless a specific criteria tells the county look forward and project what's going to be happening with traffic in 5 to 10 years. There are some criteria that require an assessment of, can public facilities support this use? And that does require a forward-looking projection, but the character of the area language is not quite like those, public facilities projection criteria that you sometimes see. So that's maybe a reason why you don't see that.
That and we've done a lot of planning, and not just review of applications, but helping cities plan 20, 50 years in advance. I've been doing this for nearly 30 years, and the only thing that we know for sure is that our planning is not going to be right. Yeah, we're gonna miss some things, and so asking an applicant to provide a burden of proof that speculates on future land use in the next in 90 square miles, that's a pretty tough hill to climb.
Did you want to comment, Ms. Sheets?
I agree. Well said. Thank you.
Okay. I saw our engineer walk in, and I was reading the staff report around traffic analysis, and I know traffic is I ask all these complex questions, and I apologize, and I realize traffic is one of those complex ones. Mr. Kurtz, I'll be looking at you a little bit, but I had expected some sort of a traffic analysis, because we know how many tons of solid waste are moving, and we know the routes over which they are moving. And so I guess I had expected some sort of a pound-mile comparison that we'd have for this application, and compared it to other heavy uses like logging. And just to ground it for us, whether this use is exceptional in terms of utilization of our transportation network, or whether it's similar to a logging operation.
Do you want to talk to the ITE manual and such analysis?
I'm not sure I'm qualified to answer that question. However, my perspective on the effect of the expansion on traffic in general is that the traffic flows are likely not to increase substantially. That the purpose of the expansion is really to maintain a use. And as a result, I mean, again, I can't speak to the motives or the goals of the organization, the corporation itself, but I would guess that that traffic would not increase noticeably as a result of the expansion. However, that doesn't mean that those uses aren't going to be there, and those uses do not have an impact. It isn't. I don't think you can accurately compare like a logging operation with what I would consider to be a daily ongoing use, intensive use. I mean, it's almost like having a logging operation going 24/7. So I'm not sure if you would gain anything by doing the pound per vehicle or something like that impact on the facility. And I guess I should point out also that historically we've had difficulty. We've been in negotiations with the landfill and with Republic Services and Allied before them at various times, to address maintenance issues on Coffin Butte Road. And one of the things they're proposing is to completely rebuild a substantial portion of that road, and that's kind of a boon to us. And as transportation systems go, I think it's an improvement that will definitely benefit those who use the facility on a regular basis, who are not associated with land use or with the landfill use. However, in terms, in terms of the actual analysis of what trucks are going where, how much they weigh, and how much they're dumping on a regular basis, I did not address that at all. So
okay.
I hope that answers your question. Did I travel off on tangents there?
Well, I understand what you've done, and I'll ask the same thing of these questions of the applicant as well. But I was trying to put in my head, how does this operation compare to other fairly heavy utilization of our transportation system?
To be honest, this use is probably one of the most intense uses that we have, coupled with of course, with the quarry. I mean, you've got garbage coming in, you've got rock going out. You know, that's heavy use. The only comparisons that I could make anywhere else in the county would be adjacent to the quarries that we have in the county. Those are the only other operations that I would consider to be analogous. I'm looking around and I do not see another industrial use in the county that really has these kinds of impacts across the board, from impacts on our infrastructure to impacts the environment to impacts water quality, et cetera, et cetera. This is kind of the boogeyman.
Sheets.
I could add to that a little bit. There is national data that has those correlations that we can capture if we need to do that. We, of course, do have a number of aggregate companies in the county. And so some of the conditions associated with those do include some additional maintenance on the roads, responsibilities. Knife River, for example, that's associated with this application. They are responsible for additional maintenance in their conditions of approval for their application. So that is absolutely in your wheelhouse to take a look at the impacts of transportation and of the maintenance of the road system. And then also not just the weight, but the ITE manual in terms of impact. And that's a trip generation manual is a nationally recognized source of estimating the site-specific trip generation for certain uses. So there's a ton of national data that will talk about the relative impacts of landfills and the haulers. And so that was used as in the transportation analysis. That is a standard engineering tool that was used as an input.
Great. Thank you. I didn't see any input from Adair Village. Can you confirm that we did not get any input from Adair Village?
Correct.
I tried to look at the detailed topographic map, and I was trying to identify where I'll call it the continental divide. Where does surface water flow towards the east, and where does surface water flow towards Soap Creek? I didn't see any analysis in the staff report, and again, I'll ask the applicant the same thing, but I was wondering whether there are any test facilities, monitoring stations of surface water either to the east or to the west. And my question to Adair Village was going to be that Bowers Creek exhausts into the Willamette very, very close to where their municipal water system intake is. Do they have monitoring of Bowers Creek to give an early warning before they intake Willamette River water for municipal use? Is there any chance we could extend another invitation to Adair Village?
Could do that, or monitoring systems. We could certainly look into those technical questions.
Very well.
I can speak to a couple other points there. On the east side of the highway, there was a mitigation area, constructed wetlands that was built around the time that the landfill built its original leachate treatment system. And I believe there are a couple of subsurface monitoring wells in on that property. I don't know for certain, and I will defer to the applicant to
And I'll ask the
clarify
same
that.
questions of the applicants.
However, there isn't any surface water testing that I believe is done on a regular basis by anyone other than the applicant in compliance with their DEQ requirements for leachate analysis and that sort of thing. However, the city of Adair would routinely test their intake waters on the Willamette, so they would be aware if there were a sudden spike in detectable pollutants. There's a whole host of Franken-chemicals that are in our environment now that are functionally undetectable without extraordinary effort in a lab, and have not reached that sort of affordability phase. So there's a lot of stuff in our water that we don't really know what it is. And so every municipality that has a treatment plant will do testing on its intake and its output to give itself an idea of how its systems are functioning. So there would be that stopgap. And there, as I mentioned, there may be other testing of surface water that is conducted by the applicants themselves.
My final question, I'm sure you're all very pleased it's my final question. I didn't see any discussion of the subduction zone risk.
I believe we did have some review of their seismic analysis. And if Ellery can manage to get back online.
Hi, I am available and able to speak now. There is, in our letter, we did reference some additional geotechnical reviews and I would say analysis be done if this were to be approved. So we have a letter. Jesse, you may have to direct the commission to where that letter is. But there is a section that speaks to the geology, specifically in the geotechnical issues, and as well as a proposed condition if it were to be approved.
So that's in BC1, which is the comments of MFA.
Okay, thank you. Now we'll move, in case any questions have come of the commissioners during the time of questioning. I got a note that Commissioner Cash would like to ask a question, so we'll begin with her. Commissioner Cash.
Can you hear me?
Yes.
Thank you, Commissioner Fowler. So I waited to the end because I was assuming this might be discussed through the questions of others, but I need to be led through something that I'm trying to track between what I read in the reports and what I have heard said tonight so far from the folks who have been, thank you for answering our questions. Okay, so I felt like the residents' concerns, the Benton County residents' concerns who had sent in their comments, we're talking a lot about these, is it PCFs going into the Willamette River? That was a very consistent theme. And then when I look at the staff report, it says we're really going to focus on noise and odor. And is that because I think what I heard stated tonight, this is now my question. Did you say we are not looking at the release of these untreated chemicals into the river because we don't have a way to track it or we don't have a facility to do the treating? And then that question would have a follow-up of, could you educate me about whether we should be treating those things before they're released into the river?
So I heard a number of elements of that question. And one thing I'd like to address first is we are still evaluating, and I hope we've made that clear in our staff report and in what we've talked about tonight, comments. And what would be very helpful for anybody submitting comments verbally or, in writing in any way, to put your address, to make sure your address is on those comments so that we can evaluate that. So that's one piece. We are still evaluating all of the comments. We will evaluate all the comments in relation to the code standards. Regarding the microplastics and our ability to regulate groundwater, I think we are limited to looking at best practice. We've asked our engineering consultants, what should we look at? How can we evaluate this? And what can we put in as conditions of approval in relation to this application? And, as a county and as something that is regulated by other agencies. And so that's, I think, what we focused on is what best practices can we assign as conditions of approval, but you don't see those conditions of approval because we're recommending denial. And so that makes it look like, maybe we haven't addressed some of these concerns when we do have a lot of potential conditions of approval that we can apply to this application. So that's a response. I think it would be very applicable to the conversation to ask the applicant, as they also have the burden of proof, to let us know how they intend to monitor and report. And we can assign conditions of approval that will allow us to also do that.
Thank you. And I think what I heard you say is that you didn't feel the need to dig more deeply into some of these other areas because of simpler issues being cause for a suggestion of denial.
I'd say to some extent that's true. We are still evaluating the comments, so there may be additional items in our updated staff report that are incited evidence that people present that can come into the staff report that will lead to different conclusions on some of the items in the staff report. So right now, our focus was on a technical evaluation of their application and their information they submitted. And in that, we had a recommendation of denial on those two items and the lack of information on the location of the shop in the FC zone. So those are things we pointed out as technical inadequacies with the application. As we bring in other testimony, there may be other conflicts, other impacts that we haven't yet considered that we will incorporate into the staff report to respond to those items that people have raised. So that's what's going on there. And this is something that we struggled with to try to explain the best we could, that this staff report is looking at the applicant submission as a technical exercise. Now, what you see on the 22nd was that, and the next one will incorporate NRAC comments, citizen comments. All of these elements will come back into play as they, hopefully, people are relating their comments to approval criteria specifically enough so that we can look at that and say, here is how it relates, and here is conditions addressing this that we recommend.
Thank you for that very clear answer. I feel educated and informed, and I appreciate that. And I'll cede the floor.
Questions, wrap-up questions from other commissioners. Commissioner Lee.
So I have a question that's just beginning to form in my mind, so forgive me while I fumble around and try to express it. Is there a chance that during this process, the staff report will get information from any source that would change its recommendation from denial to approval?
Yes.
Okay. I have several other questions. Again, in no particular order. Benton County hired a compliance officer recently. I haven't learned what the job description of that compliance officer is, and I've wondered if that officer will be reviewing compliance of conditions of approval at Coffin Butte.
Not likely, because it's such a specialized area and the operating permits are through DEQ.
Thank you. So I have some other random questions, but let me follow up about our relationship to Oregon DEQ. Because Missy, that's the name I remember you as, I apologize, I'm not trying to be disrespectful, suggested that 77.405 in the code defines our relationship with DEQ, but you expressed it in a way that is not how I see that as reading. Could you go through that again?
Just put that code section, turn it over. 77405 is a unusual code section, and it looks to our firm did a review of this code section specifically a couple of months ago. It looks like what the county wanted to do here was give the county itself, through the planning official and potentially through the planning commission, the chance to weigh in its official capacity in the DEQ proceeding that is simultaneously going on in a different world than this room. That's how I would say it. So it's a part of your land use code, but it's not germane to this conditional use proceeding.
Okay. Can I tell you how I read it? It isn't a very well written bit of code because it has so many vagaries in it. But I read it as an opportunity, as a goal to have the county involved in understanding what the issues that the DEQ is involved in and be totally transparent about when those issues become of concern. So for instance, recently, for some reason, the Environmental Protection Agency has been playing a role in evaluating conditions at Coffin Butte. And I don't know if that was the result of a chain of events that led from the county to DEQ to EPA. I mean, I don't understand that whole, who's minding the store and how transparent are they being to the county? And, that's what I want to understand.
Right. So, okay. So the title of the code section, which is a title, it's not binding, but it does say review of DEQ permits. And then it says copies of materials submitted to DEQ as part of any permit process, which I understand to mean DEQ permit.
Or
because of its context,
yes,
shall be submitted to the planning official, who is Petra. If at any time Petra determines that DEQ permit application materials or conditions of the DEQ permit are judged to merit public review, a public hearing before the planning commission shall be scheduled. So that is really talking about the parallel process of DEQ permit review that is going on outside of, separate from this conditional use permit process in which the applicant is trying to satisfy the criteria in the code only.
well, okay, so what I read it as is DEQ has a permit and it has conditions of approval. So it says in the permit process or at any time. So that's why I said, well, at any time, if DEQ is sending tech information about the status of stuff at Coffin Butte to the planning, to the county, to the planning official, and they're reading it and they say, oh, red flag here, maybe the public has a right to know. That's the way I'm reading it. It cannot, I'm not reading it as just limiting it to this period of time when there is a permit in process, but when there is a permit and its conditions of approval, which is continuous. So this leads me again, so you're saying that's not how it's interpreted.
That is correct. That's not how we interpreted it.
So
at the request of the county.
Okay. So once again, conditions of approval are not being monitored or enforced by Benton County at Coffin Butte.
DEQ permit conditions. Is that your question?
Benton County's conditions of approval. And some of those may reference DEQ and its stuff. Anyway, it gets too complicated. It's like, okay, we want transparency, we want to know, and we're in a position now where we don't know. And that's causing frustration because it limits our ability to evaluate the criteria which we're charged with. So again, soapbox, appreciate the opportunity to have a soapbox. And it's very concerning because these issues are essentially health and life for people. So I think these issues should become much more transparent. So I have another question which may not be related. Okay. I haven't heard much about the tonnage cap being lifted as a result of approval of this request. And my question is related. So right now, is Coffin Butte depositing into cell 6, which is the quarry? Is that where they're depositing now? Well, at any rate, I'm going to be asking the applicant, what's the longevity of Coffin Butte? And at what point, if we approve this application, at that point, does the franchise say that the tonnage limit of 1,100 million, whatever it is, goes away, and so that they can accelerate at any point after that, regardless of whether that material is going into the new area?
I think you're asking a question about the franchise agreement, which I would be able to get back to you on Thursday.
Okay.
I think that's what I'm hearing about tonnage agreements and thinking that's probably in the franchise
agreement. It is. It's the lifting of the cap on the tonnage. Yes. Okay. So completely unrelated, about traffic. So I hear people saying that the traffic for this new area won't change. But did I also read that there is going to be a process by which vehicles are required from, I think it's some of the people who, like individuals who go there to dump, are going to still go to the old area and get weighed, and then they'll have to cross Coffin Butte Road to take that material over to the new area? So will there be places along Coffin Butte in which traffic is going from the north to the south? Is that a new thing? Did I understand that correctly?
Historically, there has been a lot of traffic across Coffin Butte from the north side of the road to the south side of the road. It fluctuates according to with time. There have been several instances where that traffic was very intensive, and actually there were conversations with Landfill at the time about the impacts to Coffin Butte Road. And those crossings were coming, like directly across the road, like, and through temporary accesses to the north side of the road. Those occurred on 2 separate occasions over the course of the last 15 years or so. In this instance, and I will defer to the applicant regarding the domestic dump off and then the requirement to weigh elsewhere than the scales that are being proposed on the south side. But if they were to go into the existing access to the north cell and weigh there and then come out and go across the road, they would be turning right onto Coffin Butte Road from the northerly cell, proceeding to the west and going into a turn pocket to turn left to get to the south side of the road for the deposit of the materials that had just been weighed. So in terms of the, I guess, across the street traffic and such, the proposed transportation improvements would take care of that, of those motions or those traffic movements. And then at egress, those same vehicles would come out and turn right to get back out to Highway 99, where there are also acceleration lanes and turn lanes and such like that. So I don't think we're going to run into the same kind of cross-street problems that we had at points in the past. I think that the configuration of the transportation improvements will mitigate that problem.
Thank you.
Commissioner Fulford.
I've got a question regarding, it's kind of a math question. 2003, it was 2070, right? 67 years. 2013, 2050, that's 37 years. 2023, it's 2035, which is like 12 years. And now we're expecting 12 years for this next run, right? And we're going to get another 6. Are we doing the math right? Because I'm thinking here in 10 years, when I say 10 years, 8 years, in 2033, we're going to be at like 2 and not another 10 or 16. What kind of I guess math are we doing? Because we seem to miss it by quite a bit every 10 years. So are we taking that into account?
Sorry, that was a lot of numbers that you put out there.
Math guy.
I think, that's a question that is not directly related to our code standards that we're looking at right now. And I think it's a good question for the applicant.
Okay, sounds good. I'll wait.
Vice Chair Heyman.
Thank you. Really quick question about transportation again. I guess granted your assessment that the approval would not impact the level of transportation at the site, will nonetheless extend the period of time over which we experience that transportation. The permit is designed to extend the life of the landfill. And so that's not to be considered in this?
I would say existing condition is the landfill as it currently exists.
Thank you.
Are there any other questions from the commissioners? Commissioner Bisco.
I'm going to circle back. We've touched on it with a couple of the commissioners. Thank you, Chair Fowler. Related to the traffic analysis and what was presented in the staff report, and it's related to the traffic question also of Commissioner Heyman. Just confirmation, if there is an approval of this landfill expansion, to Commissioner Lee's question, I believe it is in the franchise agreement that the tonnage cap on the waste that is brought into the landfill will be lifted. Is that correct? Meaning the agreement that we have that only X amount of tons comes in on an annual basis, that will go away.
That is correct. It'll go away in the franchise agreement.
Correct.
But the land use decision, if it was approved, could include a tonnage cap.
Can you clarify what you mean by the land use? Did you say application if approved?
So the conditional use permit could include a tonnage cap. I think the tonnage cap is in the franchise agreement. If there's, and I think it says, but I really now I'm wishing I had that agreement here and I don't. If the expansion is approved, the tonnage cap goes away. But I don't see any reason why the conditional use permit couldn't include a condition of approval that imposes that tonnage cap.
Very good, thank you. With that in mind, we come back to the compliance management of Benton County. We have a compliance officer that it sounds like won't be involved in managing compliance. Conditions of approval were found during the Benton County Talks Trash process to be not enforced by Benton County, might be the way to say that, quite significantly. And the landfill in itself, under their management, did not pursue those conditions of approval and a compliance as was agreed. So in the instance, let's say that we do have that opportunity to put a tonnage cap as a condition of approval. What would the enforcement, and this is probably for Benton County, what would our enforcement options be? Because we had exceeded the cap, tonnage cap, in several years prior due to wildfires and some other scenarios that were presented. I'm not sure the actual reasons, but we had exceeded that tonnage cap before. So what enforcement options would we have if we were to put a tonnage cap on in this space? And that tonnage cap does relate to the traffic amounts that we would see and the traffic impact analysis that we've been provided.
We do have options, but we haven't gone through those scenarios. In regards to the authority, yes, we do have the authority on several levels, the methane, the fire, et cetera. There's an authority, but we have not contemplated at this point how we would be enforcing that.
Okay, and it's Ms. Harris, is that correct? Ryan, Ms. Ryan, sorry. Missy Ryan, okay. With that, would a set of conditions of approval have a greater authority than the franchise agreement, or would the franchise agreement have a legal? Where is the authority? Which one?
To monitor
overwrite
it.
the other, or, yeah,
Okay,
I'm
so
sorry.
if the conditional use permit condition included a tonnage cap, monitoring that would fall under community development. It wouldn't fall under the franchise agreement, which is a business issue. The county is how I would characterize it. So in the CDC's enforcement portfolio, they may, decide to budget for a position for inspection. Maybe some self-monitoring and self-reporting coupled with inspection. There's a number of ways to structure that.
Okay, additional, probably just requests for information. So Chair Fowler had mentioned the character of the area, the conversations are around the landfill, but to the point of that surrounding character of the area, we're talking about a lot of residential that are within that 90 square miles, right? So is it possible that we have access to like a housing needs analysis, urban growth boundary agreements for Adair Village? Do we have a housing needs analysis for Benton County that might give us some additional information on what those projections could look like, or what those boundaries have changed within this 90 square mile space?
Would be no housing analysis in the unincorporated areas. We are going through a comprehensive plan update, which will provide us that data, but not within the timing of this application process. That's going to be the next 18 months. There is information on buildable lands inventory for Adair Village.
Okay, thank you. On the buildable lands inventory. And again, I didn't quite hear what you said about Adair Village's housing needs analysis or their projections. We don't have access to that? I might have misheard you.
There is a buildable lands inventory for Adair Village.
but not a housing needs analysis.
I'm not sure on that.
Thank you. To Mr. Kurtz, thank you for your information on traffic and also impacts to that infrastructure. When we talk about the quarry operations at the landfill location, during Benton County Talks Trash, the narrative, and this may have changed, so for the applicant, if you'd like to respond to this when we get to that part too, that quarry space was being presented as a future landfill, another cell, right? So we're removing, okay, I see head nods, that's helpful. With that in mind, how is that quarry traffic, Mr. Courts referred to, and Ms. Sheets also referred to the traffic impacts of quarry trucking. So when we talk about that traffic impact analysis, have we considered that component of current landfill operations and ongoing as they extract whatever they're going to extract from that quarry?
I think that the quarry uses are going to be captured in the counts that were created by the applicant's transportation engineer. And so those uses are in place currently. And in truth, during this period of time, this period of time being the last year and a half or so, there's been a significant intensification of extraction of resources from the Coffin Butte quarry. And so traffic is about, at least for the quarry, is about as high as it ever is or has been. It's my understanding that the goal is to extract enough rough blasted rock that has not yet been crushed or graded, screened, in order to get the resource out of the way quickly, so that that cell that can then be used sooner. Now, again, I think this is a question for the applicant because they're working in symbiosis basically with Knife River to accomplish this task. And the only reason I know this is because we received a lot of complaints about truck traffic from Coffin Butte delivering rock to areas, to various areas, and there were traffic complaints and use complaints and that sort of thing. So we addressed that issue, I think, also with you all at one point. But the bottom line is that I think that the traffic counts that have been established for the traffic impact analysis that the applicant has provided represents as intense a use for the quarry as you could possibly portray. So, at least higher than what I would consider to be normal commerce. So.
Thank you for that, Mr. Kurtz. A couple questions came up from the commissioners previously about, I think it was Chair Fowler was talking about, in the process might have been known as reclamation. When I was reading this application, I was also seeing information. We've got two separate funds. I believe one was a $16.1 million fund, perhaps if I read it correctly, to manage the site after closure. But there's also a reclamation bond. Is that correct? Somebody, and that bond is intended to, in the case of, say, leachate remediation or other issues over the lifetime of the landfill after closure. Is that an applicant question? Is that a county question? Do we have numbers on what that bond is? And can you clarify the difference between that ongoing maintenance after closure and then the reclamation specifically?
We'd have to look into that specific question and get back to you.
Right.
The applicant would probably know.
Right. There's a lot of reference this evening about a secondary, additional, updated, revised staff report. Do we have a time frame on when that will be? And will we have a 7-day period before the meeting that we need to apply that updated staff report?
Yes, you will have that at least 7 days before you deliberate. The June 17th deliberation meeting.
Very good. It'll be before that. Okay.
Yes, before that. At
That's
least 7
helpful.
days.
As far as PFAS have been discussed this evening, so I'm going to brutalize, what is it, perfluoroalkyl substances, a number of many thousands of chemical components. It's a big Environmental Protection Agency discussion right now. Previously, that had not really been on the radar of EPA, and during the Benton County Talks Trash, that came into the realm of discussion, although just ever so in an introductory kind of way. It had literally just happened, and it was kind of news at the close of the BCTT process. If it is in this report, I have not gotten to that component yet. I haven't read that we are looking at that PFAS impact. So beyond the leachates, it's woven into the leachate conversation, but it's also its own conversation. Do we know if the agreements that we have with Corvallis and Salem to treat our leachate, do we know if they are treating for those PFAS at this time? Are there plans for that PFAS to be mitigated due to the nature of the EPA recommending no or next to no amount? It's a very, very small amount for the safety, health, and well-being of not only human populations, but agricultural as well. It seems to be something that hasn't risen to the top largely here, but it certainly is within, our public comment. So do we have any, are we looking at that in this process at this time?
We haven't provided comments on PFAS in the staff report, and I don't believe the applicant has provided comments on PFASs.
Is there plan to do so by the next staff report in any way?
Yeah,
Yes.
considering the weight of the public comment, once we get through all of those, there will be a response on PFAS.
Very good. Thank you, Ms. Sheets. That's very helpful.
And make a clarification on the timing of a subsequent report. We don't know when that report actually will be made based on decisions that will be made by this body, the applicant, and ourselves.
Okay,
to
so
clarify.
but we would expect before deliberations at least, maybe not a date.
You absolutely will get it 1 week before. We just don't have a tentative date.
Very good, understand. I am just going to take a look here. The current state, this will be my last question, I believe, or related questions. The current state of the DEQ permits for the landfill, do we have a status of where they're sitting right now?
No. There is I am aware of the air pollution Title V public hearing that will be occurring sometime in May. So I'm aware of that. It's been posted publicly, but I don't have any more information on that.
Thank you, Ms. Sheets. And to clarify, Title V was that one and the same, air pollution in Title V? Thank you. And do we, just maybe procedural and perhaps this is a legal question, with the investigations going on for the methane reporting with DEQ at the state, does that impact in any way this process? Is it something we need to take into consideration? Does it have to do with good standing with the county? I'm not clear, but certainly it's part of the conversation and there's a lot of discussions around that. So does that methane reporting and the DEQ review process impact our process in any way, or is it standalone?
It depends on what their answer is. We have asked DEQ for comments on this application, and they will not provide comments until we're done with this review.
I think I may be able to, some jurisdictions have a code provision that says, for example, if there's an ongoing violation, then you can't get any future permits until you remedy the violation. Benton County does not have that. And so the relevance of any DEQ issues really, it's up to you to decide if they're relevant to the conditional use criteria here, which are really the only listed in BCC 53.215. Those are really the only criteria that actually apply here, which are the staff report went through, does not seriously interfere with adjacent uses or the character of the area, or place an undue burden on public improvements, facilities, utilities, or services. So if you find that evidence to be relevant to those criteria, then yes, it's relevant.
Right.
And may I ask a clarifying question? Okay. So to be clear, the seriously interfere, we may consider methane and its emissions that exceed EPA and or DEQ requirements. They seriously interfere?
If the landfill expansion seriously interferes with uses on adjacent property or the character of the area.
Thank you.
That's the
Appreciate it.
criteria.
I'm finished. Thank you, Chair Fowler.
I'm looking one more time to confirm there are no more questions. We have gone much longer than at least I anticipated on the staff report. And we're well into the evening, and I don't believe it would make sense, Mr. Condit, to begin the applicant report at this late hour. Okay. Given those conditions, I am going to recess this meeting, and we will convene at 6 p.m. on Thursday evening back right here in this room, and we'll move immediately into the applicant presentation. To the applicant, you've seen this is a group that is more than willing to ask a lot of questions, and will provide as much time as necessary to go through the entire application as you see fit. So this public hearing is recessed.